An update from our good friends here from Earth Justice. A warm welcome and applause for the work they did today. We have a representative from the Cheyenne River Sioux Tribe as well, Nicole Ducheneau. So, welcome.
Hello, everybody. Thank you for being here and for your interest. My name is Jan Hasselman. I'm the lead attorney for the Standing Sioux Tribe. So, I want to tell you a little bit about what happened in the decision this week, and then where do we go from here, what happened today. So, the decision last week was a very significant victory for the tribes and a validation of the claims and concerns we have been raising from the very beginning of this flawed process. The court made three important holdings. He said first that the Army Corps had failed to deal with the evidence in the record that the Army Corps' oil spill risk analysis was flawed in important respects. We, Standing Rock, Cheyenne River, Oglala, had commissioned expert reports that said that challenged important parts of the Army Corps' risk analysis. The Army Corps ignored those scientific documents in its finding that no EIS was required. That was against the law. They have to go back and do it again. The second key part of the ruling was that the Army Corps not only ignored the risk of an oil spill, it ignored the consequences of an oil spill to the tribe's treaty rights, specifically to hunting and fishing, which lie not just at the core of their treaty right, but at the core of their culture and existence. So they need to look harder at what an oil spill means for tribal treaty hunting and fishing. And then finally, the court found that the court's environmental justice analysis was flawed. This is actually a pretty significant ruling. It's the first decision that I'm aware of ever in which a federal court has set aside a NEPA decision for a flawed environmental justice analysis, and that's really important. Basically, the Army Corps looked narrowly at the area around where the pipeline would be dug at Lake Oahe, and said, "Oh, look, there's 7 white people and a lot of cows. No environmental justice problem." They ignored the risks downstream, which would fall completely on the tribes. So that was the decision. We didn't win everything. We lost some stuff too, stuff that was hard. But nonetheless, the court set aside the Army's environmental analysis and said you need to do it again. You need to reconsider these elements of the environmental analysis. So, 2 things. Where do we go from here? One is, what does that process look like? One of the things we talked about in court today was that if the Army Corps goes into a room and closes the door and comes up with a new analysis, we won't have moved this ball any forward. We won't have solved any legal problem. We'll just be back in front of the court again. So our position is this needs to be an open process. It needs to bring in the public, and it needs to consult with the tribe and its experts. And we're going to be asking the court to order that if they won't do it themselves. The other question is, what happens to the pipeline in the interim? As the court recognized in its opinion, the standard remedy when a permit is found to have been issued without compliance with the law, with the environmental analysis law, is to vacate that opinion. If the opinion is vacated, they don't have a permit to operate that pipeline under Lake Oahe, and the pipeline would have to be shut off. What we talked about today was a schedule for briefing that issue. Not surprisingly, Dakota Access is going to have some strong opinions on that question. We have strong opinions too. Our view is that until there is a proper risk analysis that looks at the risk of oil spills, that considers the impacts to the tribe, they shouldn't be operating that pipeline. And we'll be saying that as forcefully as we can to the court. That process will take a little time. It'll take through August for the lawyers to exchange briefs on that issue, and we would expect a decision sometime after that, probably September. So I'm going to hand it over to Nicole Ducheneau.
Thank you. And again, I'm Nikki Ducheneau. I'm an enrolled member of the Cheyenne River Sioux Tribe, and I'm also lead counsel for the Cheyenne River Sioux Tribe in this litigation. And I would reiterate a little bit what Jan just said, that the court's decision on summary judgment in this case was a significant victory for Indian country. in light of the fact that it forces agencies, including of course the court, to take seriously our treaty rights and to take seriously the impact of infrastructure projects on minority communities, Indian communities, in this environmental justice analysis. The agencies will not be permitted under this precedent to simply elide and gloss over those issues. And so we're very happy, the Cheyenne River Sioux Tribe is very thankful that this court has said that the government has to honor its solemn treaty obligations to us, in which it agreed in a bargain for agreement with the Cheyenne River Sioux Tribe and the Standing Rock Sioux Tribe to honor and protect our right to hunt and fish in this area. So it was very important. And with regard to the remand issue, as Jan noted, it's the tribes, all of the tribes' expectation that we will be a part of this process and that we will be permitted to enter into the dialogue and provide information and consult on a government-to-government basis with the Corps as it makes its decision on these three pending issues. And as we advise the Corps today, if the Corps is going to obstruct us and work with DAPL to attempt to keep us out of this process, then the tribes are prepared to go back to the court and fight this issue out in further briefing. So the tribe is thankful for all the support that it has received. All of the tribes are thankful for all the support that we receive from activists and in the community, and from the Cheyenne River Sioux Tribe, Wokila Tonka. Thank you.
So thanks so much for all your support and for your interest. If there are media questions for Nikki or I, we can take them over here. Thanks so much.
I'm Nicole Ducheneau. I'm Nicole Ducheneau. I'm a partner at Fredericks, Peebles & Morgan, which is a national law firm that does exclusively Indian law. I'm a member of the Cheyenne River Sioux Tribe, and I'm also lead counsel for the Cheyenne River Sioux Tribe in the DAPL litigation. Cheyenne River and Standing Rock have been the two lead plaintiffs in this case since August of last year. And so today we were in court on a happy occasion because last Wednesday the district court ruled in our favor on three important issues on summary judgment. The court ruled that the EA, the environmental assessment, did not appropriately consider our treaty-based hunting and fishing rights, rights that were established for us, retained by the tribes in the Fort Laramie Treaty of 1868 and prior treaties, which are very important to us because those were bargained for between the two parties back in the days when the United States was fearful of the Lakota Sioux people, as they should have been and should still be today, and made a solemn promise to us based on this bargain based on the bargain that we made with them to protect our rights, including our hunting and fishing rights in perpetuity. Those treaties are the law of the land today. They're considered under the U.S. Constitution to be the supreme law of the land. And so it was very important to us that the court in its decision held that the Corps' failure to properly address the spill impact on those rights was unlawful. That's one issue. The second issue was the environmental justice issue. Under U.S. law, when the agencies act especially to do things that cause pollution, they have to make an assessment about whether that pollution or that government action will impact minority communities disproportionately. And in this instance, the Corps absolutely failed to consider the risk of spill in the environmental justice assessment. So the court, as Jan Hasselman said earlier, we know of no other federal decision in which the court set aside a NEPA decision as unlawful based on failure to do environmental justice properly. And then finally, the court determined that the Corps failed by not addressing the expert reports that the tribes brought in showing how DAPL's analysis, and let's be clear, the technical analyses that said that this pipeline was safe and which the Corps adopted were 100% produced by DAPL. DAPL engineers and DAPL contractors produced those. The Corps added almost nothing and rubber stamped them. So later, tribal experts and others came in and provided an alternate view, which we think is the correct view, that this was a dangerous pipeline that poses a significant, terrible risk to the waters of the Missouri River. So anyway, so we won on that last week. Yay, we were very happy. So today we were back because under normal circumstances, when the court decides that an agency action was unlawful, they cancel, they vacate the permits or the action itself. If the court had done that, that is the standard. If the court had done that, it would have stopped the flow of oil. But the court found that issue, whether to vacate the decision, had not been fully briefed. So we were back today to discuss with the court whether a briefing schedule for further briefing on the question of whether the oil should stop while the Corps goes back and considers these three new issues. Because what the court did was it remanded back to the Corps and said, you failed on these three issues and you need to go back and consider them. And so we will have briefing. The two lead plaintiffs, Cheyenne River and Standing Rock, are going to do our damnedest to convince the court that the oil needs to stop now. But in the meantime, this remand process is ongoing, and it's not clear in the court's decision whether the Corps should be forced to permit the tribes to consult on a government-to-government basis to participate in these new questions and to add new information and to advocate and to be a part of the decision. And I guarantee you DAPL is submitting their own information. And so we will be working over the next several weeks and months as the remand process goes on to force the Corps to listen to the tribes and listen to our perspective about our waters and our treaty rights and the impact of this dangerous pipeline on our communities. And as we advised the court today, if the Corps obstructs us and if the Corps fails to permit the tribes to consult on a government-to-government basis, then we will be back on further briefing to the court to decide these issues. So that's where we stand today. We've had one really awesome victory, and we're thankful to all of our supporters and to the water protectors. I was back at Cheyenne River this weekend visiting with my relatives who spent the past year at the camp, and everybody's feeling really good. But I think the water protectors and the attorneys and the tribes who are working on this issue understand that this Standing Rock Cheyenne River movement is just the beginning of a broader movement that tribes are motivated and tribal people are motivated with their allies across the country to fight against these forces, these evil forces that are harming our Unchimaka, our Mother Earth, our grandmother Earth. So, thank you.